All right, court is going to call this morning's criminal docket. When you hear your name, please say present or here. Dennis Ray Jones, Daniel McGregor, Christopher Mobbs, Amber Simpson.
Did my information show that she is at Nexus? She contacted the probation department. However, I'm not supposed to source them anymore.
Is that something that was worked out between the state and probation? No? All right, then I'll have her name called. Lisa Zutner, have a note that she's in custody in Collin County. I'll recall that case. James Murphy. Thank you, Mr. Brett. Dallas Hightower. Christina Swope. Taylor Chanel. Thank you, Mr. White. All right, are we having any contested hearings today? Or any hearings that are going to require testimony? Mr. Wheeler, y'all worked out your restitution issue, I presume?
Yeah, agreed. We'll need it.
Okay, very well. Thank you. All right, do we have any attorneys that are ready?
We're ready.
All right, good. Ms. Swope, come on up. This is cause number CR 24-66 versus Christina Marie Swope for restitution hearing.
Your Honor, we reached agreement, the restitution will be $25,000. We understand that is outside the range. It's in the indictment falls in the state. I will be discussing how to handle that. Filing appropriate documents.
And remind me, I don't recall, have we already adjudicated or placed Ms. Swope on deferred, or is this a restitution hearing prior to disposition? She's already on deferred. Okay. All right, and you said that this amount is outside of the statutory range?
Yes, sir.
Okay.
Statutory range begins at 300,000, not 325.
Okay.
We'll address that.
Okay. All right. Do we have any paperwork today that needs to be, do we have an amendment to the conditions of community supervision or anything that needs to be approved and signed in court?
We do not, Your Honor. Actually, we're discussing it out as of this morning, so I don't know if it's a brief report.
Sure, yeah. You may, yeah. You went on the record or off the Mr. Manning, you ready? Who are you ready on?
Ops.
Mr. Moff, sir, if you'll come forward. This is cause number CR 24-104, State versus Christopher Perez, Moms, pretrial.
Say hasn't gone way forward.
On the record, off the record?
Be on the record, Your Honor. I believe last time was Manning waiting on the cat interview we had given him one that was mislabeled. Since then, we've been trying to track down the correct further interview. Turns out that one was deleted and we do not have the video that was done on this victim.
And the agency doesn't retain under the
So
CAC policies, correct?
they've changed the systems around, so I can't remember the name of the system that they stored the initial videos on. They then uploaded the videos to Bidenex, and Bidenex, they keep them for forever, as far as I know. But that system, that intermediate system, it deleted them after so many weeks. So what they did was they accidentally uploaded the wrong video, labeled it as this victim's name to Bidenex. And by the time we realized the mistake, that the time had expired on the correct video. So correct, they didn't keep video. It has since been corrected because of this, but that video was automatically deleted by that intermediate system.
Okay.
Judge, I just found something disappointed. I have not discovered we were waiting on review of the CAC video. I reviewed the CAC video that was provided, obviously made the state aware that the correct one. Would ask for additional pretrial in this case, just so we can get Mr. Mons and go of discovery for the state a chance to make an offer on this case on Thursday.
And no objection.
Okay. Since you're standing right here, remind me what your schedule looks like. I've got something at the end of September. I got, well, the next evidentiary would be 26. Other than that, it'd be like October 3rd would be the next Thursday.
Judge, we could do October 3rd, that'd be fine. We don't have, at this time, we don't have any evidentiary issues.
Okay.
October 3rd, yes, Judge.
Okay. All right, and cause number CR 24-104, State versus Christopher Perez Mobs. The court is resetting pretrial to October 3rd, Mr. Mobs. Mr. Manning's got a reset notice for you to sign. Also, I showed that you're a little delinquent on your pretrial release. Are you making a payment today or have you made one this week? Okay, I show that you're delinquent $60, so we need to get that paid. Okay, all right, make sure you see, is Mr. West here? Yeah, Mr. West is around working with someone. Make sure you see him before you leave. All right. All right, Mr. Manning, who else?
Reset on this,
Sure, let's do that. Cause number CR 24-124, State of Texas versus Lisa Ann Zutner for arraignment. The court has confirmed that she is in custody in Collin County. Court will reset this for arraignment and status of custody on October 3rd. We'll do that 9 a.m. All right, court call CR 14-369, State of Texas versus Amber Michelle Simpson. All right, so I did receive this letter. Let's see. All right, so Mr. Manning, you received the same Nexus letter?
Judge, Ms. Burns sent me a letter late yesterday. I have not had a chance to review it.
Come up here and I'll show you this. Does the state have a copy of this letter? Have you seen this letter? If you want to come up here and inspect it with Mr. Manning. All right, so this letter seems to indicate that Ms. Simpson has enrolled herself into the Nexus program, Nexus Recovery Center in Dallas. Was that an agreement between the state and the defense?
Judge, I was speaking to Mr. Carwell. My understanding and belief was that prior to this representation, my previous representation of Ms. Simpson, the discussion centered around her going to this facility, this program. However, we were unable to make it work because getting her a bed from jail was not possible at the time. It appears that in the interim she has got herself into that program. That was not something that we discussed post on a reappointment on her case.
Is the state wanting the court to issue a judgment nisi alias capias, or is the state wanting me to reset for her to complete this program and return to court?
Your Honor, I'd ask the court, reset and allow her to complete the program and, be reset in the docket immediately following that September 17th. Let's see what she can try and accomplish.
All right. Assume there's no objection from the defense. All right, the court will reset Ms. Simpson to appear on Thursday, September 26th, the next contested docket.
Yes.
And we'll do that at 9 a.m. Yes, sir.
Concerning. Well,
Something real quick. All right, we're back on the record, cause number CR 24-66, State versus Christina Marie Swope. Ms. Swope, it's my understanding that you have reached an agreement with the state regarding the amount of restitution that you're going to be ordered to repay as a condition of your community supervision. I've had that discussion with your counsel, Mr. Wheeler, and also with the state's counsel. I'm going to ask you a few questions about that at this time. If you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Ms. Swope, in your agreement, has anybody threatened, forced, or pressured you to make an agreement to assess your restitution at $25,000? And you've had opportunity to discuss this fact with your attorney, Mr. Wheeler, correct? Are you pleased with Mr. Wheeler and the work that he's done for you on this issue? Do you have any questions about anything going forward? You understand that the probation department will have a document in which it will amend your conditions to include repayment of this amount throughout your period of community supervision. And they're going to present that to you later, and it will be your responsibility to sign that based on your testimony and your agreement here with the state today. You understand that? All right. Mr. Wheeler, anything you'd like to add for the record?
we will file for purposes of court and administrative agreement between the state and myself and my client, and reflect that in the event this probation is sought to be revoked, that the state will proceed on the lesser included third degree felony, which involves an amount no less than $2,500 or more than $30,000. So, no, I've got that wrong. No less than $30,000 or more than
$100,000.
That's the third degree level that will proceed under in the event of this case. Should require a motion to proceed out of adjudication. But I can assure the court that my client promises to do a good job.
Thank you, Mr. Wheeler. Mr. Hernandez, anything?
Nothing bad.
Okay, all right, then, once the agreement is filed with the court, then I'm gonna ask the state to notify the Community Supervision Department. You already have it? Okay, we have the paperwork here now. Please, Mr. Wheeler. So, Ms. Swobe, the probation department's already drafted the condition to your community supervision, assessing restitution in the amount of $25,000. You're going to be required to repay that at a rate of $220 per month, with your first payment being due on the first day of September of this year. Okay?
Thank you, Your Honor.
You're welcome. Once you sign that, then come back here and see the probation department, and then you're free to go. Let her sign first.
Yeah, ma'am.
Yes, please.
I'm tendering to the court signed copy of the amendment to the conditions of probation.
Thank you, sir. All right, I have signed that as well. And so, Ms. Swope, just come check in with the probation officers. You need to see her. Come check in with them, and then you get your personal belongings and go. That way, when you exit, you'll exit out the back. Thank you, Mr. Wheeler.
Thank you, Your Honor. Excuse you.
Yes, sir. Have a good day. Yes, sir. Okay. James Francis Murphy, CR 2479. All right, are you James Francis Murphy? Mr. Murphy, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can lower again. All right, Mr. Murphy, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? Okay. Are you currently under treatment for that? Are you on medication today? Do you feel like in any way your medication? Well, let me finish. You don't know what I'm going to say. You might know what I'm going to say, but you need to hear it first. All right. Is that medication in any way prohibiting you or preventing you from having a rational understanding of what's going on in court here today? Is it clouding your judgment or your mind in any way? All right. That's probably what you thought I was going to say, correct? Is that right?
Yes, sir.
Okay. In this case, Mr. Murphy, you are represented by your attorney, Mr. McBride. Are you pleased with Mr. McBride and the work that he's done for you? Have you had enough time to go through all of this paperwork that you've read over and signed? That's part of your plea agreement. Do you have any questions about any part of your agreement that's contained in this paperwork? Mr. McBride, do you believe that Mr. Murphy is competent today? And have you explained to him his rights as they pertain to this case, and also the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor.
And so your client understands that the court could impose the full range of punishment if he were to be unsuccessful on community supervision.
That's correct.
All right, Mr. Murphy, you are charged by indictment with a first-degree felony offense of theft greater than or equal to $300,000. That does carry a range of punishment of not less than 5 years in prison or more than 99 years or life confinement in prison, and a fine not to exceed $10,000 should you be convicted and sentenced. That's the full range of punishment. Do you understand that? I see that the plea agreement is, upon your plea of guilty, the state's recommending that the court consider the evidence, and if there's enough evidence by the court's review, that the court defer a finding of guilt. That means not convict you today, but rather defer that finding and place you on community supervision or probation for 10 years, assessing restitution in the amount of $52,215.33 to be paid joint and several with co-defendant Charles Hairston in cause number CR 2472, along with court costs of $290, reimbursement fees of $35. Mr. Murphy, is that your understanding of the plea agreement? And as part of that plea agreement, you understand that if Mr. Hairston doesn't pay a single dime, that you're still obligated for the entire amount. Okay. All right, then, Mr. Murphy, understanding the range of punishment, understanding the plea agreement, how do you plead to theft of property greater than or equal to $300,000? Are you pleading guilty to that crime because you are guilty of committing that crime? And has anybody threatened, forced, or pressured you to plead guilty? Court will accept the defendant's plea of guilt at this time. Mr. McBride, any objection to the stipulation of evidence being admitted?
No, sir.
All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, just that the state is compliant, good of those states that are supportive of the plea. And just for the record, there was an unfiled money conversation proceeding, which the state has respected, I think that's part of it.
Thank you, Mr. Harwell. Mr. McBride, anything further?
Yes, sir. Small items. One is, the defendant lives in San Marcos, Texas, and we're going to ask probation to transfer it over to San Marcos. So it's more convenient. Right now, it's driving 4 hours to try to get to court. So it'll be inconvenient for him to be able to do that. He understands that he may have to report once here before the interstate transfer. Tri-state transfer is. But otherwise, he's going to ask for that. And the other thing, I just want to mention to the court. He's been honorably discharged and did 3 tours in a row. And I think this has been very well on probation. It is our anticipation we won't need the full 10 years to pay that back. And assuming he gets everything done prior to, just expect that he'll come back to this work and see an early termination once everything is taken care of. Just wanted to be aware of.
Appreciate that. Of course, the transfer to another county is going to be contingent upon the probation department's approval of that. And the only way they're going to know that is to know more about Mr. Murphy and those things. Are you sure that you don't want to meet with probation first to make sure that there's no hiccups before you enter into this agreement?
Proceed.
Okay. Okay. All right. Court's going to review the evidence at this time. All right, the court, having reviewed the stipulation of evidence, finds that there is sufficient evidence to convict Mr. Murphy of this offense. The court will follow the plea agreement and the recommendation of the state in this matter. Cause number CR 24-79, this court defers the finding of guilt on the first-degree felony offense of theft of property greater than or equal to $300,000. The court, well, before I go any further, just because we dealt with this restitution matter a moment ago. So I see that the charge is greater than or equal to 300,000. And the restitution in this case is 52,000.
Yes, sir.
Can we reconcile that?
That is the difference between, insurance basically paid off all of the 50,000.
Thank you. That's what I need to know. Court defers a finding of guilt, places Mr. Murphy on 10 years community supervision, assesses restitution in the amount of $52,215.33 to be paid joint and several with co-defendant Charles Hairston in cause number CR 24-72. And there's no restitution or anything being ordered to the insurance company. Is that correct? Court also assesses court costs of $290, reimbursement fees of $35. Since we're having an in-person hearing, I'm going to get rid of the waiver of in-person hearing there. All right, and so this plea agreement, I'm going to need this to be filled out. There's no information in here. It's all blank. Y'all signed it, but there's nothing in here about charge, offense level, or anything. So I'm going to need y'all to come get this and fill it out. Yes, please. All right, Mr. Murphy, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. After that, you'll step over here and see the probation officers, and they'll tell you what happens next.
And that is.
Yes, thank you, Mr. Wright. Do you have anything this afternoon? And Mr. Manning, are you aware that Mr. McBride filed a motion to substitute on one of your cases?
Okay,
Josue Rodriguez? Okay, I want to make sure you're aware. All right, Mr. Manning.
Mr. Dennis Ray Jones.
Mr. Jones? This is cause number CR 24167, State of Texas versus Dennis Ray Jones for arraignment on unlawful possession of firearm by felon. Go ahead, Mr. Manning.
Yes, it does. Judge's case here in court. I explained to him the charge, it's split charge against him as well as range of punishment. Including the enhanced range of punishment in this case. You understand the charge against him, if that's felt correctly. At this time, he pleads not guilty and requests to be set on a pretrial docket.
All right, the court, having found Mr. Jones to be indigent for purposes of the Sixth Amendment, has appointed the Honorable Jonathan Manning to represent Mr. Jones. Mr. Jones, also having waived the formal requirements of arraignment, enters his plea of not guilty into the record, and we set this matter for pretrial on October 3rd at 9 a.m. And Mr. Jones, have you signed your conditions of pretrial release with Mr. West? All right. All right, once you get your notice of setting, you're free to go. Yes, thank you. Do you know, Mr. Manning, do you have any contested this afternoon?
I do not do that.
Okay. All right, we'll see you this afternoon. Yes. Sir, appreciate it. Okay. This goes with that other, I got Mr. Murphy. Daniel McGregor. All right, this is cause number CR 24-172, State of Texas versus Daniel Edward McGregor. Mr. McGregor, you have been charged by indictment with a second-degree felony offense of sexual assault of a child. That does carry a range of punishment of not less than 2 years or more than 20 years confinement in prison and a possible fine not to exceed $10,000. I also see that you have requested a court-appointed attorney. The court has reviewed your application for indigency. Based on the value of your vehicle and your income, you do not meet the indigency level requirements. So what I can do today is I can reset your case for about 30 days and give you time to make arrangements to either hire an attorney or represent yourself. And representing yourself obviously carries inherent risk because you're assuming you're not an attorney, you're not trained to do that. So I would advise you against doing that now and advise you that it's in your best interest to gather your resources and hire an attorney. So I'm going to reset you. Do you have anything to say about any of that? I don't want to hear anything about the charge, just about hiring the attorney.
Now, I'm curious, about the agency, eligibility, how does that qualify to, have,
Well, I think that you indicated that you had a car that was valued at $12,000. Yeah, I understand that, but you have a car that's worth $12,000 that you could go sell, correct?
it's only worth like $1,000, of that.
But that's not what you put in your paperwork.
I'll pay it, well,
Well, it said the value of the car. It didn't say, I thought you just said it was only worth 1,000. So why did you say it was worth 5,000? No, it says the value of the car. That means the value today minus any liens. I'm going to reset you for 30 days and I want you to go revisit your resources. I want you, if you need to file new paperwork, then you can file new paperwork. But what you swore under the penalty of perjury is what you had, and that's all I can go off of. So you put one thing on paper and then you tell me another thing here today.
I was I was thinking that I put what I paid.
Why don't you go back, once you go out in the hallway, Miss Tabraham, apparently he didn't either one, read it, or two, he didn't understand it, or three, he didn't read it and understand it. So give him new paperwork, read it, pay attention to it, and only put down information that's true and accurate, and don't come back in here until you get that done. Morning, Mr. Schmidt. How are you? It's like being in my living room sometimes. You got paperwork in the process, or are you ready? You ready? Mr. Hightower, come forward, sir. Cause number CR 23-217, State of Texas versus Dallas. Justin Hightower, motion to revoke. Go ahead, Mr. Schmidt.
Judge, the state filed an amended motion to Mr. Hightower on Tuesday, talked to Mr. And then I think we're gonna work this out. We'd have to set it for about 30 days out. 30.
You want that October 15th date? I think that's what we've been doing. I know it's a little more than 30 days. I can have you back on, if you want something sooner, I can do September 26th. That's the next contested docket, 15th. All right, court will set Mr. Hightower for plea before the court October 15th at 1:30. Mr. Schmidt, while I have you here, do you have any contested hearings this afternoon? Okay. Right now, I don't think that we'll be bringing anyone over from the jail then for an in-person hearing. All right, so Mr. White is still going over paperwork for Mr. Chenault, I believe. And then I'm waiting on Mr. McGregor, and that'll be the final two for this morning. Court's going to stand in recess for about 20 minutes or so and allow the attorneys time to talk with their clients. All right, this is cause number CR 24-93, State of Texas versus Taylor Evan Chenault. Mr. Chenault, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. Thanks, sir. You can lower your hand. Your name is Taylor Evan Chenault, is that correct? And Mr. Chenault, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with any type of mental condition? Are you currently under a doctor's care for that? All right, are you on medication today? Do you feel like those medications are helping you today, or are they in any way hurting you or preventing you from understanding what's going on in court? Okay. In this case, you are represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work that he's done for you as your attorney? Do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered? Is there anything about this paperwork that you've read over and signed today that you do not understand? Mr. White, do you believe Mr. Chenault to be competent? And if so, have you explained to him the advantages and disadvantages of a deferred adjudication plea?
Your Honor, I would. Is indicated, what's going to occur in this case. I have explained to the advantages and disadvantages of a deferred adjudication. I would understand those. We've also got before the court waiver some documents.
Thank you, Mr. White. All right, Mr. Chenault, you are charged with a state jail felony offense by indictment of publish or threat to publish intimate visual material. A state jail felony does carry a range of punishment of not less than 6 months or more than 2 years confinement in a state jail prison. Also, a potential fine not to exceed $10,000. I see that the plea agreement that you've reached with the state is that you would plead guilty to this offense in exchange for their recommendation that the court consider the evidence, but defer a finding of guilt, not convicting you today, but rather placing you on community supervision for a period of 2 years, along with a $1,500 fine, $290 in court costs, and $35 in reimbursement fees. Is that your understanding of the plea, Mr. Chenault? All right, understanding the range of punishment, the court finds that it is fits within the range of punishment, the plea agreement that is. The court then asks you, Mr. Chenault, how do you plead to the state jail felony offense of publishing or threat to publish intimate visual material? Are you pleading guilty to this crime because you are in fact guilty of committing the crime? And has anybody threatened, forced, or pressured you to plead guilty? All right, court does accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
That there's the unfiled harassment case that we have recommended as part of.
All right, and is there victim approval or victim communication, or is the state in compliance with any kind of victim notification requirements?
This looks kind of weird. I expected this case to be one where we are supposed to reach out to the victim, but this particular charge is not one that puts that on us. So we have not reached out to the victim in this case regarding this plea, just simply because it's one that where our victim assistance coordinator it's not in the statute for her to do it.
So even though with regard to the sensitivity and the nature of the charge, you're saying that the DA's office did not have any contact with the victim who was displayed in the intimate visual material?
Correct. And it was a surprise to me that it's not part of the statute for victim services. However, because of that, we did not.
Okay. Anything further from the defense? All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant of the offense. Court will follow the plea agreement based on the recommendation of the state of Texas. The court hereby defers a finding of guilt on the state jail felony offense of publish intimate visual material. The court deferring a finding of guilt places the defendant on 2 years community supervision, orders him to pay a $1,500 fine, $290 court costs, and $35 reimbursement fees. Mr. White, can the court be assured that any of this visual material that was published by your client is no longer visible in this chat that was conducted between him and the multiple people referenced in the stipulation of evidence?
I understand.
And can y'all turn on y'all's microphone so that yeah, I hear you.
As far as I know, the images taken. They're still out of public domain. You know, the other way.
Mis-
And Your Honor, the chat, I believe, was a private Facebook group. And then so it was open to multiple people, but it was a private group, and that group didn't take it down. The way this came to our attention was a member of that group, we believe the moderator of the group, recorded the.
All right, thank you. All right, Mr. Chenault, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez, then the probation officers will give you more information. Mr. White, do you have anything this afternoon?
I hear.
No, not here, unfortunately. Okay, a little further from home. All right, Mr. McGregor. All right, you have completed a new set of paperwork on your affidavit of indigence and request for court-appointed attorney. I do have some questions for you. I want you to raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you provide to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, so Mr. McGregor, originally in your first application, you indicated that your take-home pay was $800 a month. And then in your second application, you said that your take-home pay is $150 a week. Those two amounts don't reconcile. So why did you report it was $800 and then at most we're looking at $600? How many hours are you working a week? 15 to 20? And so you've disclosed that you believe that the value of your car is $4,000, and that's what you believe that you could get on an open market if you were to sell a car. Is that correct? And you list that you have zero expenses. Like who supports you? Who? So you don't have, what about your car insurance and your gas? And what about your gas? So you don't use the car? So you got, so, go ahead. No, that's okay. My paperwork is still telling me that you're not indigent because you've got you've got income, you have an asset that has some value to it, and you have zero expenses. So the law doesn't allow me to appoint you an attorney unless you fit that criteria. So what I'm going to do is I'm going to reset you until October 3rd, and that's more than 30 days. And so I want you to pull your resources together, and I want you to start contacting attorneys, and I want you to contact as many attorneys as you can, and I want you to report back on October 3rd whether or not you're able to hire one. And I want you to bring back copies of all of your pay stubs. Okay. And I'm telling you that with an asset, your car, um, you should be in a position to where if you're not utilizing that car, that you sell it for what it's worth, and that gives you money to pay towards an attorney. That's that's what the law expects the law expects an individual that has an asset to liquidate that asset, to sell that asset and get the funds rather than requiring the taxpayers to foot the cost of an attorney. So that's what the intent of the law is, and the parameters that are set up in the law regarding your income, your assets, and your monthly expenses creates a formula, and that formula is what courts have to follow. And right now, you're coming out on the positive side of that formula. Does that make sense? Well, I'm going to give you until October 3rd to try to get all of that pulled together and figure out what you're going to do, because I told you before, you're looking at a very serious charge of sexual assault of a child with a range of punishment 2 to 20. So it's very serious. So this is the time that you may have to go find a full-time job, or uh, pulling your resources together means if you can work more hours, you can get a better paying job, you can sell your car, all of these things that are necessary for you to afford to provide for an attorney to give you a legal defense. This is what you need to be focusing on. All right. So I expect when you come back on the 3rd, you bring your pay stubs. And if you don't have an attorney hired, then I need to know how much money you've saved and how many attorneys you contacted. And I need to know their names and when you contacted them. So you need to write all that information down. All right. Yeah, if you can find an attorney to represent you pro bono, that's within their discretion if they want to do that. If they want to provide you a defense without being paid, that's up to that attorney. All right, that concludes this morning's criminal docket. We're going to stand in recess. We will resume at 1:30.